Vladimir Putin arrived in Mongolia on 3 September 2024. As a signatory to the Rome Statute, it is legally bound to arrest Vladimir Putin, who is subject to an arrest warrant issued by the International Criminal Court. Mongolia has not arrested the suspect, and instead afforded the suspect the red carpet treatment in welcoming Putin to Mongolia. This is Putin's first visit to an ICC member state since the arrest warrant was issued in March 2023. He is accused of war crimes of unlawful transfer and deportation of a population, children, under Article 8 of the Rome Statute. Mongolia's international legal obligations are clear as a member state of the International Criminal Court, ICC. They must arrest President Putin and hand him over to the ICC to face charges of war crimes. As set out by Amnesty International, President Putin is a fugitive from justice. Any trip to an ICC member state that does not end in arrest will encourage President Putin's current course of action and must be seen as part of a strategic effort to undermine the ICC's work to prosecute suspected war criminals. If the Mongolian authorities fail to arrest him, they will have done nothing but give succor to a man who is accused by the ICC of being responsible for the war crime of unlawful deportation of children, but is also potentially responsible for a plethora of other war crimes and crimes against humanity in a conflict that has shattered the lives of millions and destroyed the hopes and aspirations of a generation. This thread addresses what the obligations are to arrest Putin, what the role of the court is, and what the consequences may be for failing to adhere to the statute by a signatory state. So what is the ICC? The primary mission of the International Criminal Court is to help put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole, and thus to contribute to the prevention of such crimes. What is the International Criminal Court? The International Criminal Court, the ICC, or the Court, is a permanent international court established to investigate, prosecute and try individuals accused of committing the most serious crimes of concern to the international community as a whole, namely the crime of genocide, crimes against humanity, war crimes and the crime of aggression. What is the Rome Statute? On 17 July 1998, a conference of 160 states established the first treaty-based permanent international criminal court. The treaty adopted during that conference is known as the Rome Statute of the International Criminal Court. Among other things, it sets out the crimes falling within the jurisdiction of the ICC, the rules of procedure and the mechanisms for states to cooperate with the ICC. The countries which have accepted these rules are known as states parties and are represented in the Assembly of States Parties. How many countries have ratified the Rome Statute? Over 120 countries are states parties to the Rome Statute, representing all regions: Africa, the Asia-Pacific, Eastern Europe, Latin America and the Caribbean, as well as Western Europe and North America. Under what conditions does the ICC exercise its jurisdiction? When a state becomes a party to the Rome Statute, it agrees to submit itself to the jurisdiction of the ICC with respect to the crimes enumerated in the statute. The court may exercise its jurisdiction in situations where the alleged perpetrator is a national of a state party or where the crime was committed in the territory of a state party. Also, a state not party to the statute may decide to accept the jurisdiction of the ICC. These conditions do not apply when the Security Council, acting under Chapter 7 of the United Nations Charter, refers a situation to the Office of the Prosecutor, who can be prosecuted before the ICC. The ICC prosecutes individuals, not groups or states. Any individual who is alleged to have committed crimes within the jurisdiction of the ICC may be brought before the ICC. In fact, the Office of the Prosecutor's prosecutorial policy is to focus on those who, having regard to the evidence gathered, bear the greatest responsibility for the crimes, and does not take into account any official position that may be held by the alleged perpetrators. Next, exemptions and politics. If those who bear the greatest responsibility hold high political or military office, are they not exempt from prosecution? Can they not be granted immunity or amnesty? No one is exempt from prosecution because of his or her current functions or because of the position he or she held at the time the crimes concerned were committed. Acting as a head of state or government, minister or parliamentarian does not exempt anyone from criminal responsibility before the ICC. In some circumstances, a person in a position of authority may even be held responsible for crimes committed by those acting under his or her command or orders. Likewise, amnesty cannot be used as a defense before the ICC. As such, it cannot bar the court from exercising its jurisdiction. If the ICC issues an arrest warrant against a current or former head of state, is it for political reasons? No. The ICC is a judicial institution with an exclusively judicial mandate. It is not subject to political control. As an independent court, its decisions are based on legal criteria and rendered by impartial judges in accordance with the provisions of its founding treaty, the Rome Statute, and other legal texts governing the work of the court. What are crimes against humanity? Crimes against humanity include any of the following acts committed as part of a widespread or systematic attack directed against any civilian population, with knowledge of the attack: murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity, persecution against an identifiable group on political, racial, national, ethnic, cultural, religious or gender grounds, enforced disappearance of persons, the crime of apartheid, other inhumane acts of a similar character intentionally causing great suffering or serious bodily or mental injury. Does the ICC have the power to arrest suspects? The court does not have its own police force. Accordingly, it relies on state cooperation, which is essential to the arrest and surrender of suspects. According to the Rome Statute, states parties shall cooperate fully with the court in its investigation and prosecution of crimes within the jurisdiction of the court. Who has to execute the warrants of arrest? The responsibility to enforce warrants of arrest in all cases remains with states. In establishing the ICC, the states set up a system based on two pillars. The court itself is the judicial pillar. The operational pillar belongs to states, including the enforcement of court orders. States parties to the Rome Statute have a legal obligation to cooperate fully with the ICC. When a state party fails to comply with a request to cooperate, the court may make a finding to that effect and refer the matter for further action to the Assembly of States Parties. When the court's jurisdiction is triggered by the Security Council, the duty to cooperate extends to all UN member states, regardless of whether or not they are a party to the statute. The crimes within the jurisdiction of the court are the gravest crimes known to humanity, and as provided for by Article 29 of the statute, they shall not be subject to any statute of limitations. Warrants of arrest are lifetime orders, and therefore individuals still at large will sooner or later face the court. Next, legal requirements of member states. What is the legal requirement of a nation-state to arrest a suspect who is subject to an ICC arrest warrant? The answer is found under Article 59 Arrest Proceedings in the Custodial State. A state party which has received a request for provisional arrest or for arrest and surrender shall immediately take steps to arrest the person in question in accordance with its laws and the provisions of Part 9. A person arrested shall be brought promptly before the competent judicial authority in the custodial state, which shall determine, in accordance with the law of that state. It shall not be open to the competent authority of the custodial state to consider whether the warrant of arrest was properly issued in accordance with Article 58. What do the ICC do if a member state fails to comply with the treaty, and refuse to arrest a suspect subject to an international arrest warrant? If a state fails to comply with a request to cooperate, the registry or the OTP might refer the matter to the relevant pre-trial chamber, which in turn may refer a state's failure to comply to the ASP, or, where the UNSC referred the matter to the court, to the UNSC. Article 87(7) of the statute. This provision in the treaty states, where a state party fails to comply with a request to cooperate by the court contrary to the provisions of this statute, thereby preventing the court from exercising its functions and powers under this statute, the court may make a finding to that effect and refer the matter to the Assembly of States Parties or, where the Security Council referred the matter to the court, to the Security Council. Members of the International Court are bound to detain suspects if an arrest warrant has been issued, but the court doesn't have any enforcement mechanism. Conclusion. International criminal courts and tribunals have been established on a belying enforcement paradox between their significant mandate and their inherent lack of enforcement powers. Their endogenous frailty lies on the predicament that, unlike their national counterparts, they are not backed by systemic law enforcement. Instead, they are left to rely on external forces to procure enforcement. Although the creation of a permanent international criminal court marked a fundamental turning point in the pursuit of international criminal justice, the ICC must also rely on state cooperation and judicial assistance in order to secure arrests. Despite the solid legal underpinnings of the enforcement regime under the Rome Statute, it is argued by some that the ICC has thus far failed to achieve desired results due to its persistence in rejecting the factoring of politics in the enforcement of arrest requests equation. Getting suspects into the dock at the International Criminal Court, ICC, has proven to be a formidable challenge for the permanent court. Lacking its own police force, the ICC depends on determined action by governments whose commitment, under the influence of competing diplomatic or economic objectives, can be fickle or in some cases outright missing. Improving the delivery of justice faces many hurdles, but the arrest of its suspects is a particular weak spot that affects the court in a profound way, and it is now clearly demonstrated with Mongolia failing to arrest Putin on his visit today. As an act of compliance with international criminal law, arrest pits execution of a court's judicial order against the prerogatives of a sovereignty-minded, albeit legally obligated, state. Perhaps a revision to the statute which extends culpability to the leader or leaders of a member state who refuses to comply with the legal obligations, which will result in the issue of an arrest warrant for them too, might jig a sense of responsibility and obligation into being a signatory to the statute. An extreme measure, sure, but it will resolve the flaccid state between court administration and the upholding of the statute. Mongolia is a recalcitrant government that is now arguably implicated in the crimes of the alleged perpetrator, and shields or refuses to arrest a suspect whose whereabouts are well known. If the ICC fails to act, it loses all of its credibility. Let us not forget to balance our understanding and expectations of this fractured war crimes court not-so-global statute. Remember Bush signing into law an anti-ICC U.S. law back in August 2002. U.S. President George Bush signed into law the American Servicemembers Protection Act of 2002, which is intended to intimidate countries that ratify the Treaty for the International Criminal Court, ICC. The new law authorizes the use of military force to liberate any American or citizen of a U.S. allied country being held by the court, which is located in The Hague. This provision, dubbed the Hague Invasion Clause, known informally as the Hague Invasion Act, is a United States federal law described as a bill to protect United States military personnel and other elected and appointed officials of the United States government against criminal prosecution by an international criminal court to which the United States is not party. The text of the Act has been codified as Subchapter 2 of Chapter 81 of Title 22, United States Code. The Act gives the President power to use all means necessary and appropriate to bring about the release of any U.S. or allied personnel being detained or imprisoned by, on behalf of, or at the request of the International Criminal Court. There was an attempt to repeal the bill, but it died in Congress in 2022. This bill was introduced on April 14, 2022, in a previous session of Congress, but it did not receive a vote. Although this bill was not enacted, its provisions could have become law by being included in another bill. It is common for legislative text to be introduced concurrently in multiple bills, called companion bills, reintroduced in subsequent sessions of Congress in new bills, or added to larger bills, sometimes called omnibus bills. Has this content been useful to you? Would you like to see more research and translation content from Beefeater Fella? If you do, and you want to stay up to date with my work, please take a moment to like this video and subscribe to the channel now. It takes just a few seconds and it's free. This is really important. Your support and recommendations can make a big difference to the channel.